So I will go through a couple of slides just to get us talking, really. But I'm hoping that that the main thing we're going to get from this will be a lot of opportunities to chat about your practical experience and what has worked well for you or what you think might work well for you. And so hopefully you guys can see my screen there. So I think most people in their daily lives, regardless whether you are an artist, a scientist, a computer coder, no matter what area of work you are in, you have ideas and you have a capacity to bring a creativity to your work. So all of us use our mental faculties in one shape, form, or another to create ideas. And one of the central principles around IP, some of the things that I'll talk about today are very simple, straightforward, and basic ideas. But I think if you grasp the basics of IP, the later stages make a lot more sense. I suppose we all have ideas, and ideas in and of themselves are not actually intellectual property that can necessarily find legal protection. And in and of itself, an idea doesn't make you any money, right? I suppose it probably seems a very straightforward equation to say that you have to have the idea, but you also have to put together the actual invention or build a prototype or do some experiments to show that something is going to work in order to actually show that your idea could have a commercial value or could create some value for the end user. So if we look at innovation, innovation is really the output of this process of taking an idea and developing it into something that has a value, which may be a commercial value or it could be a societal value, and not necessarily in every case is that value to be quantified in dollars or euros, but essentially if the idea has a commercial value, then it may be worth protecting. And I guess that's why I titled this talk about creativity, this worth protection, because not all ideas are protectable unless there's actually something in it that can be I suppose commercialized, then it's very difficult to argue for why would you take out an insurance policy on something if it has no value? Why would you take out an insurance policy on an old shed that has no value and that would not be, replaced if it was to fall asunder? Whereas if it's something that actually has a value to you, like your family home, you would go to great lengths to protect that. And so the question needs to be around what is the value of this invention? And for those of you who are helping small businesses, I suppose that's a really practical question is what is the value associated with this business and with this idea? And from that point of view, I always think that a business strategy needs to be talked about before you get into the minutiae of IP. So you need to have a concept of where this business is going and why the IP matters in that bigger context. So there are two things that I suppose are really key for any discussion around IP. The first is what's the commercial value? How are you going to use this idea? How are you going to make money from it? And who's going to buy it? Because a brand has no value if people don't see that it has, a glamour factor or an attractive factor or some form of wow, that you want to buy that particular product as opposed to a generic of the same thing. And so has it got a commercial value? And then the other aspect, which is really important and is completely different, is it legally protectable? And I would say, look, the law is a completely different beast than commerce. You guys who are already in business know this extremely well, but a lot of people tend to forget that the law is just a set of rules. It's not justice, despite Lady Justice. It's a set of rules, and particularly in the areas of trademarks and patents, there's a lot of the law comes down to meeting particular rules and regulations as you go along with the filing. And people come to me sometimes with questions saying, "Oh, but I've used this, name for a long time. Surely I have rights in it." And the answer is you might or you might not. You have to know a little bit about the law in order to see if you meet the legal criteria. So just because something works well, in the law, it doesn't mean that it works well commercially. And just because something works well commercially does not mean that it's going to be legally protectable, by the same token. So it's really important that we don't confuse those and conflate them and assume that the one means the other. They don't. And I guess this is probably the most complex slide I want to talk about today because there's a lot of concepts on here. The first one is intellectual property. So what is intellectual property? Would any of you guys like to hazard a definition of what's intellectual property and why is it different from intellectual property rights as such?
I'd say intellectual property describes methods and systems that have commercial value, that are owned hopefully by you if you have the rights.
Yeah, so the key word there, as you say, is property. They're actually legal pieces of property, or they may be legally considered pieces of property. So they're assets. They're assets to a business. And there are so many different types of ideas which are not actually ownable assets. So for example, if I have an idea for a smartphone app, um, the idea itself is not necessarily intellectual property that I can own. It's just an idea. So intellectual property goes a little step beyond an idea and it becomes an asset that you can possess. And intellectual property rights then, does anybody want to hazard what's special about the rights that you can acquire? Are they, tell me a little about them. What do you guys know already?
So the rights are a right to the ownership of that IP at the exclusion of everybody else.
Or the right to exploit it, yeah.
Exactly. So there's two things there. There's the right to use it, the freedom to operate in that space. So if you're thinking of working in an area, you need to make sure you're not already treading on someone else's toes. And the second aspect, as you said, Rob, is it's a monopoly right. It's a right to exclude other people from manufacturing, making, selling, importing, whatever it is that you have this particular right over. And like any other legal right, these are jurisdictional. So just because you take out a patent in the US does not mean that you will have protection in Australia. If you take out a trademark, registered trademark in Ireland, then it doesn't necessarily provide you with any protection in Qatar. So this is why I say it's really important that we think about the legal side of it and the rules side of it, because intellectual property rights are specific and there are rules associated with them. And most of them are not that difficult, but you do need to actually have a look at what the rules involve in order to, I suppose, to really get the best out of them, because people make an awful lot of mistakes by making assumptions. So even though, as I say, IP law is not the most difficult form of law, it certainly creates a lot of confusion for people. Okay, so there are a number of different areas here, and one of them probably applies to most of you, given what you've told me about your businesses or your interests here, and that's confidential knowledge. And I suppose the basis of a lot of IP law is all around confidential knowledge. So confidential knowledge can be your lists of your clients. It could be the recipe or the formula that you have for your chemical compound or your dishes in your restaurant. It could be how you put together your, your machine on an assembly line. Lots of people have confidential knowledge, and in fact, most ideas start as most inventions start off as a form of confidential knowledge. Some types of confidential knowledge can be protected by such as patents or utility models by particular IP rights. So patents would be one of the names, I suppose, that people bandy around a lot, because a patent is a very, very powerful form of protection for an idea. Patents are granted from governments, and they're basically an exchange. In the simplest possible terms, they're an exchange between the government of the company, government of the country, and the owner of the idea. So in exchange for making that knowledge public, the owner gets a legal right, a monopoly right, to produce and sell and license that invention for up to 20 years. So essentially, then that information is published, goes into the general public's awareness, and anyone can produce the same technology once that patent term has expired. And I guess I use patents as an example because most IP rights work in this manner. Most IP rights are time finite. So if you look at design rights, that is protection for the appearance of a product, or the appearance even of a shop, or the appearance of some packaging or some form of trade dress up. And again, design rights are made public, but they give the owner of that design right an exclusive use of that design for a finite period of time. Trademarks, kind of the same thing, except that a trademark can be renewed indefinitely. So by making known that you have a particular mark, you are advising other people that they can't use it. And again, you're paying for that privilege, and trademarks typically last for a decade and can be renewed. If you look at copyright, that would cover new art or new content, and that's very loosely defined, as you know, in copyright law. So even if you write, for example, a blog post, that would be covered by copyright law, and you have a moral right to be known as the author of that. And copyright then is related normally for most of us to the lifespan of the author, 70 years after the author's death. But again, there are exceptions, and every country is a little bit different, so it's important to note that. And then there are other kind of more specialized areas, such as database rights, which might apply to some of you. I know there's some tech companies here, and there are specific areas where you might have databases or lists which are compiled with specific skill. And there are other little niche rights as well, like plant variety rights, but I don't think anyone here today specifically needs us to talk about those. But I think those are probably the main areas. And I guess what's useful is to note that for most companies, there'll be a bit of this and a bit of that. So you might need to think about more than one type of IP right. So the question I would always ask people is, what is it that you need to protect and why? So Rob, in your case, you were talking about, if you're working in aerospace, or if you're working with something that's, an invention, then the likelihood is that your first protocol is you think, this is an invention, can I actually get a patent granted for it? Some of you guys have gone down the route of looking at patents, and you realize that it's quite complex piece of patent law is very complex. And it's very technical. And sometimes when you speak to a patent attorney, you can wonder if they speak English at all, because everything has to be described in particularly tricky jargon. And I suppose the reason for that is because patent terminology needs to be extraordinarily clear and precise, because you're not granting a patent for an idea, you're granting a patent for a very specific idea, and that the idea itself needs to be laid out in a particular way so that your invention can be compared to other inventions. So the state of the art that existed before you, you need to demonstrate how your new invention goes beyond the previous state of the art. So what is the difference between all of the other patents that exist and yours? So if you did come up with an invention and you were interested in finding out whether or not it might be patentable, just from a point of view of, suppose, a place to start, I just want to share a different screen with you and show you a couple of other places to start looking, because I guess one of the things people wonder is what can I do myself? What can I, sort of how do I go about starting even this? So I just want to show you a SPASnet. So SPASnet is a patent search tool, which will allow you to go and look up what other patents exist. So if I was to go into, say, smartphone, and do a search in a SPASnet, I would be able to go in there and look up patents. And look, there'll be hundreds of them. So we've got thousands and thousands of different patents, and you can look them up, and some of them will be in all different languages and whatnot. So, but we can have a look, and you can scroll through them, and you can search for different things, and look for all different types of text, or look for different filters, as to what type of thing you want. When was it? What country? What language? And you'll be able to actually have a look. Now this one might be in Korean, so not the easiest to read for all of us. But I suppose the idea there is that you can have a look and see what's there, and you can be quite specific about it. So if I wanted to look up, say, electric fence or something like that, and you can have a look and see what has already been, filed already. And the more you go digging, the more you might find that the idea that you have has already been invented, or maybe it hasn't. And that, as I said, gets very technical. So if you're in doubt, or if you're not sure as to whether your idea is really novel, then what you can do is contact a patent attorney, and it shouldn't cost you anything to have a preliminary chat with a patent attorney as to whether something or might not be patentable. And their area of expertise is having a look at all of these and comparing state of the art with your invention. And as you probably know, they'll be looking for a couple of things specifically. One is to see if your idea is truly novel. So is there anything else on the market that is exactly the same or very similar? Inventiveness is the secondary. You actually have to have invented something that goes beyond. So you must have an inventive step that goes a little further than the previous, and many patents are iterative improvements. They're not necessarily all groundbreaking. So I suppose, it's an area where I would harshly recommend you to have a conversation with a professional. Patents are extremely technical documents. And for the purposes of today's chat, I think that's the most important point to take away, is that because they are extremely technical, a patent attorney, and I am not a patent attorney, a patent attorney would be your first port of call for genuinely investigating whether an idea is likely to reach that standard of patentability or not. So that is Espasnet, which is one of the most basic tools. And actually, you'd be amazed, a simple internet search is very effective in helping you decide whether something has already been invented or not. So if you try and describe your invention in plain English and do an internet search, you'd be amazed how many times you will find exactly the same idea. It already exists somewhere in the world. And a little analogy that might be useful to you in terms of understanding, the idea of novelty and inventive step and the different tests that are applied for patentability. This is a really simple one, but it's, I think, a useful idea is to think about a rocking chair. Okay, so if you had a patent in existence for a chair with 4 legs, and you have a patent in existence for a cot with rockers, those are 2 existing technologies. So the question would be, well, if I was to put rocking wheels, or kind of a curved piece of wood under a regular chair with 4 legs to turn it into a rocking chair, would that be patentable or not? It would be novel because it would be, a new idea that was combining 2 existing technologies, but would it really have an inventive step? And the answer would be no. Why? Because putting the 2 technologies together is quite obvious. And inventive step does require going a bit beyond just putting together 2 and 2 and making 4. You really need to add something new, something that is inventive beyond just 2 existing technologies. And that's actually a really simple example, but it gives you an idea of just how complicated patent law can be to try and figure out, well, why is that? What is the difference between putting together some technologies? There must be something that's truly innovative, something that goes beyond the state of the art. Whereas in that example, you can see there are 2 pieces of state of the art that have simply been pushed together. The other thing to say about patents, people often wonder whether computer code can be patented. The answer is code in itself is not patentable. It's covered by copyright, yes, but it's not in itself patentable. However, there are computer implemented inventions. So the code could be integral to the computer achieving an output. And that in itself, as a computer implemented invention, might be patentable. So again, it's so complicated. There's no way we could cover patentability issues in an hour. We could have several different sessions on that. So my strong advice to all of you would be, if you have a question about patentability, please do consult a patent attorney, even a preliminary chat. They will often be able to solve that initial question of, is there a possibility of a patentable invention in this? And the reason why that's so important at an early stage is because patents are one form of IP that does not last. If you allow your invention to become public knowledge, and that can be as simple as telling one other person about it, you have let the cat out of the bag, and it is now state of the art. It is now normal knowledge in the public domain. So if you present it at a conference or publish it in a journal, then you have allowed that idea to be put out into the public domain, and you could actually have undermined your own capacity to obtain a valid patent. So that's just one really, really important point. And if you take nothing away from today, other than that, it is that patents are destroyed really easily by disclosing your invention into the public domain, at too early a stage. So a small bit of advice will go a very long way with regard to checking out patentability. So that's probably one of the key points that people make the mistake of being super proud of their idea and letting the cat out of the bag too early. Patents are expensive. People often say, well, you know, this is going to be an expensive process. It certainly is. Patents are thousands and thousands of euros. If you look at the process, they are extremely expensive. However, a patent attorney would guide you through the process in terms of how much is payable at what point, because, you know, the whole idea really with the patent is that it needs to present value for money in the long run, and that you need to be able to license or to exploit the value of that patent and to get something back for it. So you don't necessarily have to build the thing yourself, but you certainly need to be able to show that it can be built. That it is in fact commercially and industrially applicable. That's the third criteria for, you know, for patentability. It must be industrially applicable. And that's probably the easiest of the patentability criteria. So I say the other two, novelty and inventive step, as they are probably the harder criteria to reach. And that's a little bit about patents. You know, and in terms of, as I say, that the most important thing about them is not to disclose. So if you are going to go to a third party, maybe get working on a prototype or trying to have, you know, a viability study or work with other partners on IP that would need to work alongside your idea. So you might need to license somebody else's IP to work alongside your own to make your invention work fully. And if you're getting into those kind of conversations, protecting that knowledge, making sure it's not publicly disclosed, that it's only disclosed under strict confidentiality, and I mean explicit confidentiality agreements, is so important, so that you can argue that you have not disclosed your invention. And as I say, take the advice of a patent attorney before you proceed, because those are the kinds of areas where people easily trip up with patents. That is one of the big, I suppose, key registrable rights. A lot of things are not patentable. And I think, Fayolati, you mentioned that, you know, if you can't patent something, you may have to revert on trying to keep that knowledge secret. And that can fall back on trade secrets, which is, I suppose, a very old form of law, where we're dealing with rights of confidentiality or breach of trust. And in this instance, I suppose the most important thing is that you actually have secure the knowledge in some way, and that you can show that you have taken steps to secure and keep confidential that knowledge. So that would mean things like looking at your contracts of employment. If you have any employees working for you, making sure that you have clauses in your employment contract around who owns the IP that is created in your company, and around keeping that information secure and confidential at all times. So that in itself is a really important part of employing people, and you should definitely have appropriate clauses. And if anyone wants to talk to me about those afterwards, we'll have more time. We can have a look at what non-disclosure agreements for third parties should look like, and what employment contracts, the covenants that you might, protective covenants that you might insert into an employment contract in order to secure that. And I would also say, look, you know, as a small business owner, you might be thinking to yourself, what do you mean? You know, what does this mean to a small business where I don't have, you know, an inordinate amount of information, but I still need to show that I kept it confidential. I still need to show that in actual fact it was kept in trust. And how do I manage that with other people? So I suppose this is really practical, ordinary business stuff, like keeping your information in a secure location, keeping it maybe in a protected drive, or making sure that you have taken adequate protective steps to keep your IT secure. So cyber crime is one of the big areas, as you know, in 2020, where we've all probably experienced a much higher level of cyber crime and cyber attacks. And you know, it's really important that you would consider those areas of your business that might actually have confidential knowledge, and making sure that you've secured it either physically in a locked drawer or with appropriate IT protections. And believe it or not, that's actually important if you do go to, you know, to sue on the basis that someone has breached confidence and has you know, absconded with your trade secrets. The other thing that you might have seen in your own employment contracts at some point, or perhaps you have them in your employees' contracts, are non-compete clauses, and the effectiveness or not of those, is something that we could debate. But I think it may be important to people who do rely on confidential knowledge, and also on lists which are compiled with skill. So things like, who are your suppliers, or who are your clients? They might be, lists that matter tremendously to some businesses, and they might be worth keeping, as I say, with that level of security, so that you can rely on them as though they were trade secrets. So then there are a couple of other areas that people mentioned this morning. I suppose chief among them was brands, but before I talk much about brands, I just want to mention design rights. Design rights are kind of like a little bit of a halfway house insofar as they apply to a product. So they're not a patent. They don't protect the way something works. They protect the way it looks. So design rights can be registered or unregistered. Unregistered rights just arise when you have gone to some trouble to create, I suppose, a pattern or packaging or some form of design. It applies a lot in the fashion industry because, as we ladies are very aware, I'm sure you men are too, the fashions change quite a bit, and particular looks come and go from season to season. So the length of time a design needs to be protected might be quite short in certain industries. And unregistered rights are quite short, but they may be sufficient for your purposes if you are working in a fast-moving industry and the need for protection is, lower, and you don't need it for as long. But you can, in fact, take out a design protection on product, or on a packaging, or even on an app button or something like that for your website. So if there are particular features that you think are adding value to your product, your service, or your business in some way, a design right is quite a cost-effective way of protecting the look and feel of things. And I'll give you a couple of examples of some of these things now in a little while. But branding, on the other hand, then is more specific. It's looking not at the whole overall appearance of a product, but more at a part of it. So many of you guys are working in your own businesses. You'll probably have a company name. You probably have a name by which your customers know you. Would that be right? Anybody out there trading as something, or would have a company name that you put hours and hours into thinking about?
All of us probably.
All of us have, yeah.
Yeah. So, and that kind of becomes your baby, doesn't it?
Yeah.
Yeah. So the trick about brands is that they are so evocative. I think we all get quite het up about brands. And if I asked you to drive a Fiat down the road, you'd feel quite differently if I asked you to drive a Maserati. Why? Because the brand is what creates emotional response in a lot of people. So the appearance of something is great, the packaging. If you go out and you buy something in Brand Thomas's, you get a lovely bag with some ribbons, and you get the general feel of it. But it's the fact that it's got Brand Thomas on the front, and it's got stripy black and cream, and all of these little touch points come together to give you, a brand. So the trademarks could be the name of the company. You might have a trademark for the name of the product. So you don't just have L'Oreal, you have L'Oreal Elvive or L'Oreal Nice and Easy or whatever. So there's product names, as well as house brands, which are applied to products to give them a value. And again, I would often say to people, this is where you need to remember that there's law and that there's commercial awareness, because people often create names that are very good in a commercial setting, but are not legally protectable. And again, the law is simply a set of rules, and they will be applied kind of systematically by a trademark examiner. So a small bit of knowledge at an early stage goes a long way in helping you to have names or logos or pictures or imagery that can actually tick both boxes of commercially useful and legally protectable. Sometimes people find they've already gone down the path of having one or the other, but maybe not both together. And there are some ways that I can help you to overcome that. So if you have a very descriptive name for your business, say Bray Doors and Windows or something like that, or the Cottage Bakery or something like that, and it turns out that you have very little that is unique and distinctive, your customers might love it, your product might sell like hotcakes, quite literally, but you might not be able to protect it because it's so descriptive. So if it's Bray doors and windows, I cannot stop any other company in Bray from selling doors and windows and using the words doors or windows. And again, people forget that because they say, well, I'm selling doors and windows. I know you are, but so are other people. And a trademark is a monopoly right. It's a legal right to exclude all others. And I think people sometimes forget that when they're trying to register a trademark, because when they do it themselves, it's their baby and to them, they're the only one. But that's not really the case in the world. So again, if I was to give you a very cheap and easy way to do this, I would say do an internet search, type in your name, or type in, do a Google search for an image and put in your image and see what comes back at you. You'd be surprised how many times even that will show people who are using very similar names to the one that you have in mind. And another tool I'd really like to show you is a very simple one, but one that you can use yourself. I think it's great to be able to do some of these things yourself. So it's TMView. TMView is a trademark search tool. It's again extremely easy to use. And if you want to go in there and put in, a name of a trademark or something like that, you can have a look and see if we find anything. It'll find everything similar. So it'll give you loads of different trademarks. And you can go in and you can filter again, like with our other searches in Aspasnet. Trademarks are really easy because they're not so hard to read as patents, and so you'll be able to do a lot of this yourself. So you can see there you've got hundreds and hundreds of trademarks. Apple Pay, Apple Keg, Apple Guy. You can be quite specific. You can search only for the ones that are currently registered or the ones that are filed. And you can do a little bit of a search to make sure that your name is not already in use. Now, there's a big difference between doing some searching yourself and a full freedom to operate search. That would be quite an expensive process, and IP firms will do it for you. So if you're investing an enormous amount of money, then I would recommend that you spend a proportionate amount checking out freedom to operate. But if you're a small business on a shoestring budget, then at least these are some simple tips that you can use to try to avoid falling into some really obvious pitfalls. Now, as you can see, there are tons of Apple trademarks, and you might well be saying to me, how come there are all these Apple trademarks? Surely you can't, these businesses can't all be coexisting. And the answer is, well, they are, but they're doing different things or they're in different countries. And again, this is really important principle, applies across IP rights. I mentioned it at the start, they're legal rights and they apply in particular jurisdictions. And there are rules around them. So it's possible for people to have trademarks for similar things. So for example, or for different, either different trademarks for the same item or the same name of a trademark, but across different items. So for example, some of us might think of the word Triumph and you might think of ladies' underwear, and other people might think Triumph and think tires. And so Triumph is just a simple word, but it's been registered in respect of completely different goods and services. So all trademarks have to be registered related to particular goods and services that you actually want. And here in the goods and services file, you'll see what goods and services. You might think to yourself, holy cow, what does that mean? How do I know what goods and services 16 are? Well, if you have a look further in to the registration, you'll be able to find out more about it. And it'll tell you. So now this one's actually, for books. And each of those categories of goods and services have a subsidiary list in them of all of the different items. There are 45 in total. The first several cover goods and the last few cover services. And for you to be able to find a trademark, you need to know what goods and services you want. So if I went to the EU IPO website, which is very easy to use, I heartily recommend it. And it's a great place to go for anyone who wants to learn about IP rights, and it's full of information on both trademarks and on designs. And you can apply for an EU trademark. The process is very similar for Ireland, but I'm going to show you the EU version because it's extremely similar. And if you can do one, you can do the other. But the EU IPO will cover the entire of the EU zone, and it will help you using these tools to make sure that you classify your trademark in respect of the correct goods and services. So this is a really handy little website. And even if you are going to go to a trademark attorney, myself or any other trademark attorney, I think it's a really good idea that you do this yourself first to start to understand what the process is going to involve, so that when you go and you talk to those people, you're a little bit more informed and you have an idea in your head what you're going to be talking about. So you can go in here and you can search, and it's really simple in plain English. You can put in the goods and services that you want. So if I wanted to launch a line of shampoo, I could go in and I could search for it, and it will actually bring me up all the options. So you can say, oh, shampoo, I'm in class 3, body cleaning. That looks exactly what I'm looking for. And you can see that there might be more than one type of shampoo. So carpet shampoo would be a very different product, I suppose, than shampoo for your hair. So this is a very easy, there's pet shampoos, and you might think, oh, that's grand, that's very easy going, I have no problem with that. Certain goods and services are a little confusing, and you might say to yourself, I'm not sure how I ended up in this particular or that particular set of goods. So in particular, services are quite hard to categorize at times. You might be thinking, what exactly is that? So let's just run a search for, let's just run a search here for adding a manual service. So if I went into, say, for example, 44, and I went into doctor services or something like that, and it might bring me up some option, okay? Because it won't recognize doctors, but it will give us some choices. Probably running a little bit slowly now because we're on Zoom as well. Okay, and it says, look, it doesn't like it. So it says, I don't have an exact match for that. I'm going to give you the opportunity to amend that. And very helpfully, it'll allow you to make selections that will meet their criteria. So it's extremely user-friendly. And there you go. So you can decide if that's a good and accurate description for you, for your trademark. And that goods and services builder can actually be imported into your trademark filing then. It's really handy, it's very easy to use, and it will help you to get a kind of more rational thinking in terms of what your goods and services are, and what way your trademark might look when you actually think about it in respect of those goods and services. So again, if I was coming along and I said to you, I'm opening a business, I want to call it Apple, I'd be saying to you, well, you can't have Apple in respect of, say, Apple products like apple pies or apple chutneys or apple jams. You can't have Apple in respect of computers because that's already taken, but you might well be able to get Apple in respect of medical assistance consultancy. And so I guess that's a little bit, I know that's quite a quick introduction and certainly far from showing you everything there is to know about trademarks, but it's giving you a very basic idea so that you can apply a few of your own searches before you end up talking to a professional. Save yourself a little bit of time and trouble. One of the big pitfalls that I see people make with regards to trademarks is when they have something that's too descriptive. And I talked a little bit about that earlier on about grey doors and windows and why you can't have a monopoly right over something that is generic. It's also important to note that you can't have a monopoly right over something that's false. So I can't, for example, set up a company and call it Diamond Knives when in fact I'm selling knives that are made out of silver. So they can't be deceptive, they can't be completely misleading to the consumer. So I can't have a brand called something about wool when in fact my clothes are made of cotton. So I suppose there are a few principles there, and again the EU law is relatively readable, but sometimes it can be quite specific. So my advice again would be to talk to a professional before you spend a lot of money on filings, because once you apply for a trademark, that application fee will not be refunded if your application is not successful. So have a think about the brand, have a think about what assets make it up. So it could be a name, a logo, and again, think about the value of it for you as to whether it's commercially worth a lot of money to this brand, or whether in fact, the brand is one that will last the pace, because a trademark will last you for 10 years. So will you really get 10 years of good value out of a trademark, or are you planning on changing it anyway? you know, or if you need to make changes to it, why not do that first, so that when you do file it, you file the right thing. Probably one of the problems that I see most often, people coming to me saying, oh, I filed it in yellow, but I really wish I'd filed it in green. And unfortunately, you cannot make any changes once you've submitted your filing. Same is true with designs. You know, it's really difficult to make any changes afterwards. It's just the, you know, whether it's at Irish level or EU level. And again, the trademark examination offices are extremely helpful pre-filing. So I really do recommend people think about, you know, getting that advice. And the EU IPO even have a pro bono program for small businesses who need to avail of free support. So I really do recommend that people think about that as well as a good option. So let me just, yeah, I see a couple of questions coming in, and I will very quickly come back to you just in terms of the Enterprise Ireland offering, because Enterprise Ireland do have support, a couple of supports in fact for this, and they can help you with the cost of some of these I suppose searches that you might need to do, also with the filings that might arise as a result. So I'll show you those now on the EI website, and providers like myself can come to you and can help you and provide you with a level of support, and also educating people within your organization. So if you're an EI client, it's a really great way of availing of some financial assistance for this. And the other area where you might be able to get help if you're a smaller company is from the local enterprise offices. A lot of the local enterprise offices can provide you with mentoring grants. And so I work with Enterprise Ireland on one of it, but I also work with the local enterprise offices to deliver solutions for smaller businesses who maybe just need a couple of hours as opposed to a major program in this regard. So let me just share the screen with you on the page for Enterprise Ireland, because that's, I think, a particularly helpful. Joe Doyle is the gentleman in Enterprise Ireland to speak to about these grants. He's a really nice fellow, very approachable. So I heartily recommend you ding him on LinkedIn or give him a call and have a chat with him about either the IP Start grant or the IP Plus grant. And as I say, people like myself would be the kind of consultants who would work with you on either of these types of projects. So the IP Support grant, the plus, I suppose, is probably the more useful for larger organizations. So you can see there that you can get quite a lot of money. You can get up to 70,000 euros of grant towards, you can get 50% of the 70 grant as your grant, which is really quite a lot. And that can actually cover filing fees if you go about it the right way. So, you know, I heartily recommend you have a think about this. I won't go through all of reading it at you, that would be pointless. But I recommend that you Google it afterwards, and you can see there that there's different types of strategy offers, big ones and small ones, depending on your needs. And as I say, the local enterprise offices have mentor grants, and some of them have mentors like myself on their panels who will give you IP advice. And so that is some fairly straightforward grants that you can avail of. So just going back then, till I show you the last little bit here, just we had looked at the brands. One thing that people forget sometimes is to check out if you can have the domain that matches the brand that you have in mind, the trademark that you have in mind, or the company name that you have in mind. So you could end up filing a couple of different things. And if you're a new business or a new startup, you might want to file your trademark, a domain name, maybe multiple domain names, all at once. And I think it can be kind of important because there is a bit of cyber squatting going on. It's been quite prevalent in 2020. Once you apply for a trademark, it goes into the UIPO system, or it goes into the TMView system, and other businesses can see at a glance that you have applied for a name. And what happens then is, you know, people will come along and they'll say, I know that's going to be a business. And so they might either send you letters saying, oh, we'll put you into this directory, or we'll put you into that directory, or we will sort of maybe more nefariously, we will steal your domain name out from under you if you haven't already registered it. So just to be aware that those are public filings and consequently people can exploit them. So unfortunately, you're very likely to get letters saying your trademark has been registered and now we want to put it into directories. So again, if in doubt, check it out. Don't just pay an invoice. You should never ever get an invoice from any unknown company, and some of them are quite convincing and they look like they're international organizations, but they may not be legitimate, so be very careful of that. And then just, I thought this is a nice little example of a product which has many different parts of its being protected by different types of IP, and I just wanted to share this little example with you. So you can probably guess that's an iPhone. The iPhone has loads of different pieces of technology in it which are protected by patents. The iPhone has design rights taken out in it. So you've got the patent, just an example of one of the patents involved in the iPhone there, which is to do with the interface, is to do with the technology that allows you to use your finger to act as the stylus. The second piece is the design. So underneath the patent document there, you can just see the registered design, which protects the shape and the appearance of the product. And Apple, that's a huge part of their business plan, if you like. It's a huge part of the value they deliver to consumers, is that the actual appearance of the product is very valuable in and of itself. Then there's a trademark, which is applied to it. And then there's the actual software which is inside the phone, and that software is covered by copyrights. And Apple have had quite a lot of copyright cases, some of which are quite exciting and groundbreaking in their own way. So that one piece of technology is covered by at least 4 different types of IP right. And I guess if there's one more final takeaway from this, it's that there's rarely one piece of IP that covers every aspect of your business. So every business has IP, every business has ideas that are worth protecting. But the question is, what value would you put on them? How upset would you be if it was your business and somebody copied the name or the shape or the technology that's inside the box? And if you would not be upset by somebody in Australia doing it, then you don't need rights in Australia. If you would be upset by someone in Clondalkin doing it, then you might need rights in Ireland that would protect that particular feature. And the question then is, what's the best right? What fits the need that you have? Is it for the technology? Is it a patent? Is it for the look? Is it a design right? Or is it in fact best that you look after the brand and people buy it because of the trademark that you apply to it, whether that's your company name or your logo or anything else? So that's a really simple example. And like I said, just, today we're here on very much an IP 101 type course. It's all introductory, but I would just say to you, always think about this quick checklist. Have I thought about why I need protection? Have I thought about which rights best suit my need? Who's going to be the owner? Is it me personally? Is it a company? Will I be licensing it? Who's going to actually, be the owner of this right? What jurisdiction do I need it in? And if any of you are going away from this thinking about that question of, how can I audit my IP? Well, I would suggest you make a list and that you look at each of your IP assets, whether it's your company name, your logo, the colors that you use, your trade dress, the ideas that you have in your business that are valuable to you, the content that you create that will be covered by copyright. If you write blog posts, if you write instruction manuals, all of those would be covered by copyright. Have you made an inventory asset register for all of those? And have you got appropriate rights if you need them, if you actually want to invest in them? And are they in the right jurisdiction? And if you have registered rights like patents, trademarks, or designs, do you know when they're next up for renewal? Because they will elapse if you don't tend to them. And it's one thing to apply for them today, and then 10 years later, maybe your business address has changed, maybe your email address has changed, and you don't get the notification of renewal. And the next thing is your right is gone. So it's a really good thing to maintain your own asset register. And that can be important for your trade secrets as well as for your registered rights. Know what you have, know how you protect it, know who you're protecting it from. And then the question arises, as I say, is this working for you commercially? Is it working for you legally? And will it cover your likely future development plans? Have you future-proofed this? Because most of these rights are quite long-lasting. For example, a trademark, as I said, don't file a trademark if you're planning on rebranding next year. Have a think about what you're going to rebrand first. So is it timely? And is it going to be future-proofed? So if I am filing a trademark, we looked at shampoo a couple of minutes ago. If somebody came to me saying, look, I've got a brand for my shampoo, I'd be saying, okay, should we also include conditioner? And they say, well, I'm not yet making conditioners. I say, is it likely that you'll do so in the next 5 years or so? And if the answer is possibly, then it's better to include that the possibility is borne in mind, and you can easily file for both, so long as you're not in conflict with somebody else. And as long as you do go ahead and use it, then it's it's a good mark. And if eventually you don't use it, well, then conditioner might be taken away from your trademark eventually, but shampoo will be maintained. So you've nothing to lose. So always think ahead. So those are some really simple, very basic, I suppose, ideas that underpin a lot of IP. And I know we're at the end of our time, but I'm not in a rush. I'm happy to stay here and answer any questions that people have. So I would just like to have a little look there in the chat box in case anyone has sent any questions. I think we've covered quite a few. Yeah, as Fran said, yeah, there's New Frontiers have some really useful stuff as well. There's a couple of other websites I should point out to you. Knowledge Transfer Ireland, they have really great resources. A lot of the IP law firms have great blog posts. F4 Kelly's, I have to say, have redone a lot of theirs on their website in the last year, and they have some really good resources. So there are a lot of different places that you can go to get some pointers, and people like myself are generally speaking very amenable to having a chat, giving you a few ideas, or having a preliminary chat without charging you. Of course, going down the road, you will encounter fees, but they should be proportionate to the work that you need done. So it's not a bad thing to lift the phone to ask for an estimate of what would be involved. A little professional help goes a long way. So I sometimes think, look, it's possible to perform surgery on yourself, but whether it's wise is another matter. And I guess that's the case with IP, is that sometimes you can do a good bit of digging and looking yourself, but it is advisable to take an expert's opinion. And like I say, sometimes, you may find that the first opinion is not the best. You might want to shop around a bit, and that's another little takeaway, I guess, is a good thing. You need someone you can speak to and that you can relate to, and that really understands what your business model is about, because your IP strategy should always be a subsidiary part of your whole business strategy. So someone who purely talks about this trademark or this patent and doesn't look at the bigger picture is not going to do you as much favors as someone who really understands how it integrates into your business and how you plan on making money from it in the long run. Because as I say, if it has no commercial value, then why have a legal protection?
Thanks, Mary. I'm gonna drop off. Thanks for your help.
Fran, thanks a million. As I say, this is very introductory, so any more specific questions, do feel free to give me a call afterwards or drop me a message through the Ireland Together platform.
Thank
you.
Wonderful, Mary.
Fran,
Thank
it was
you.
lovely to meet you. If you do want to stay in touch on your PhD, let me know, because we might be able to give you some information. So, Mary, that was fantastic. Thank you so much.
Yep, thank
so
you, Mary.
much information.
Really welcome. I know a lot of it's
they're very general if you have time.
Yeah, a lot of it is very general, and I'm very conscious that people's business information is extremely sensitive, so it's hard to talk about it in a group setting. But I think branding was obviously a big concern for a lot of people, and I'm very happy to take questions offline about that so that we can address your individual concerns. And like I said, if anyone has patent related questions specifically, I'd be very happy to put you in touch with a patent attorney who will again have a chat with you without charging you for that preliminary chat about patentability.
So one of the first things I was thinking of was So we have a lot of early stage startups in the community who are at the, doing an MVP or starting to get some kind of viable app or product together using outsourced tech developers. So in that situation, is there any need for them to protect the IP, or do they just need to establish that they own the code?
It's a really good question, Joanne. I think it's terribly important to protect the idea. So the question is always, where is the value? So you might say, if this is a new and novel way of addressing a problem, it may be that you have a process that could potentially be patentable. I mean, look, the likelihood with processes is quite likely not, because you have to have gone above and beyond what else is out there. So these are not ideas that people come up with every day to have something that groundbreaking. But on the other hand, if there's any possibility, I think it's a good idea to have a chat, just to rule it out, just to make sure that you're not missing anything, just to make sure that that you have considered the possibility that there would be something there that is a patentable invention. If you are taking a technology that you know already exists and adapting it or changing it in a way that is not going to be patentable, then the question is, how are you going to exploit the value in it? What are you really bringing to the table? The question is always, what are you bringing? So if you are going to be developing an app that's going to be used in a parallel industry, or it's going to bring a technology from one space to another, you might not be too happy if 10 other folks do it at the same time as you. So being first to market can be terribly important, and that can mean maintaining a level of secrecy or confidentiality around it, because you don't want competitors hopping in at the very beginning. Good example might be in 2020, a lot of businesses went online and started delivering services like, delivering things online, even ordering drinks from a bar. You might now have an app, to do your ordering from your phone as opposed to going up to the counter. And so people who are developing apps maybe to tend to this new need come along and go, well, actually, you can deliver your groceries on Tesco. Maybe I can create a little app that'll deliver my drink or whatever. So in that type of situation where you're catering to a new need, being first to market is really, really important. And if you are hiring a developer from some other place, whether it's a third-party company in Ireland, third-party company from Delhi, it doesn't matter. You need to think about the same concerns. How do I protect my space, my confidentiality around my idea? And having non-disclosure agreements and non-compete agreements might be very important to you. I would say to people who are thinking of having, a person in some far-flung region of the world create code for them, it can be really attractive on the face of it to go for the cheapest possible option. But if you are in another jurisdiction, are you able to deal with the law in that other jurisdiction? So if you hire someone to work in, Bangladesh, how are you going to actually manage that person? How are you going to maintain confidentiality? How are you going to deal with it if there's a dispute, or if your idea somehow pops up in a competitor's place? How are you going to even tell if they breached your confidentiality agreement? So, again, that's not to say that any one industry or any one country or anything is better than another, but just make sure that you have the reach to be able to deal with legal issues that arise wherever you put your business. And it can be just as difficult in Walkinstown or, in Wanaka in New Zealand. It doesn't really matter about the location, it matters about the law and whether or not you can enforce it. So it's certainly an area of concern.
Yeah, I think it's a really interesting one though, because if you're doing something like, if you're developing a prototype that is not groundbreaking, well then maybe you can do that offshore, you can do that where there's not so much risk. But if you actually feel like you're developing something that's groundbreaking, inventive, maybe it's safer to do that in a region that at least you understand, or you've gotten advice, or you understand the legal kind of ramifications.
Well, yeah, I mean, it can be very expensive when you go in, and it can be more complicated and less intuitive for you if you don't know the law in other countries, or if you don't have, so for example, dealing with something in China, you're going to need interpreters, you're going to need someone who knows the law over there, you're going to need a solicitor on the ground, someone who can physically walk into a building, because in China a lot of things still have to be done in person. which is remarkable considering how amazingly forward they are in tech. But they actually have a lot of, quite literally, you must walk into the bank in order to make certain types of, to lodge certain types of documents. And again, in court, you physically have to appear in local courts in China. So you have to pay someone to be on the ground for you. And you have to pay to have documents couriered and sworn, go to embassies. There's so many complications involved in certain countries. Like I say, China is one that to me jumps out as just being extremely onerous to progress legal proceedings in China. So it really depends. So there's a question around, I suppose, the reputation of the parties that you work with, and choosing reputable parties to work with is not just about what language they speak or what country they come from. As I said, there are plenty of cowboys everywhere. But if you do your due diligence on the partners that you choose to work with and make sure that they have good reputations and that they have worked with other reputable parties, and satisfy yourself that they are in fact good people to work with and partner with. And always protect yourself. Get your own commercial solicitor to look at your non-disclosure agreements or your confidentiality agreements that you put in place between you and third parties. The more valuable your idea is, the more you need to protect it. It's like an insurance policy. And the last thing to say, I suppose, in terms of going abroad and getting advice from abroad, it can be really tempting to go for things like an online brand builder or logo tool or something like that. Just be very careful that what you actually sign up to, you read the small print on, because people can purchase, images and logos and stuff like that. And then, as I say, you do a simple Google search and you'll find that 10 other companies are using them and you have absolutely no IP rights in them whatsoever. And so if it looks cheap and it acts cheap, it probably is cheap, unfortunately. And I suppose I would urge people to try and create something that is unique and bespoke, particularly for their brand, something that really reflects the values of the brand itself, something that tells your consumers something about you, but maybe in a less literal way. So don't just pick a random swirl or swoosh because somebody can sell it to you for a cheap amount of money, and then you come to a trademark attorney, because that's just throwing good money after bad. And I think, realistically, you're better off to invest in developing the good brand first and protect it later. So like I said, patents are a different ballgame. You need to look after your patent filing before you disclose it to anyone else. But with trademarks and other aspects, it's not such a time-sensitive matter, and it's more important to get that brand really working, so that it's going to be commercial success as well as, a legally protectable brand. It's a bit of a balancing act.
Yeah, sure is. Any other questions, guys?
No, that was very informative. Thanks, Mary.
Yeah,
You're really
thank you,
welcome.
Mary.
Thanks, Rob. It was great to see you.
Thank you very
Hope
much.
to see you all at the Ireland Together Christmas
Thanks, Mary.
party.
Yeah.
Yes, yeah, looking forward to it, Mary. Thank you so much.
Great. Well, thanks
All
so
right.
much for your time. And